IVM.
Welcome to Police Chowki, a special limited series on your favorite public policy podcast, All Things Policy. This series will take you behind the khaki uniform, beyond the flashing red beacon, and into the heart of the functioning of the Indian police force. We cast a critical eye on the role and function of the police in the Indian democracy, from the silent persistence of paperwork and meticulous investigation to risky counterterrorism efforts and policing in conflict zones. We explore the need for police reform and accountability in the system. Each episode brings you a comprehensive exploration of a unique facet of policing, illuminated by the insights of a former IPS officer who has lived the life behind the badge. So join us every Monday morning as we take you into the complex world of Police Chowki.
Hello and welcome to another episode of Police Chowki. I'm your host Shrikrishna Upadhyaya, and in today's episode we'll be delving into the intricacies of the criminal prosecution process in India. We had done an episode earlier called Crime Investigation and Accountability, where we actually looked at criminal investigations from the moment a crime is reported to the methods employed by our police forces in cracking the crime. Today we'll be taking a deeper dive. Using the example of a murder prosecution, we'll peel back the layers of the entire process of criminal investigation and prosecution. While our previous episode, highlighted the broader aspects and challenges of investigations, today we will put the spotlight on the finer procedural details involved in prosecuting serious criminal offenses. And before I begin, a warm welcome to our guest on the show today, Mr. Javeed Ahmad, former IPS officer and DGP of State of Uttar Pradesh. Welcome back to Police Chowki, Mr. Ahmad.
Yeah, Shri, thank you and pleasure to be back.
So, Mr. Ahmed, I have a simple question for you before we begin talking about murder and prosecution and so on. And this is actually a basic but fundamental question. What do you think is the purpose of criminal justice? Because there have been many theories put forth by criminologists, philosophers, politicians, and so on. And there have been talks of retribution, deterrence, rehabilitation, restitution, and even restorative justice in the last few decades, which sort of try to justify punishment for committing crimes. So in your opinion, what do you think is the purpose of criminal justice? And in your experience, how do you think this is played out?
Okay, so before we talk about punishment, we need to just step back and talk about why the state was formed in the first place. The state in the Hobbesian, framework was formed as a part of a social contract, so that each individual could pursue his own interest in the best way that he could. And there was a state that was to ensure that the rules of the game were followed and that no one was intruding into the rights and into the property of the other. So that is the basic, framework on which any state was formed, including those that exist today. Now, when a state was formed, one of its major functions was to punish those who crossed the line or who committed a crime. Now, what was the purpose of crime? There have been various theories and there have been various phases in which different thoughts went behind the punishment given to an individual. Punishment, as you know, is a means for deterrence. The second thing that we need to highlight right at the beginning is that punishment is given to the individual who has committed the crime, not to, for example, his family or to his, known. All those who are seen as directly or indirectly involved in a crime are to be punished. Now, I highlight this point in today's times because we have seen the spectacle of so-called bulldozer justice, in which a person is alleged to have committed a crime and his house in which his wife and his children and others may be living is brought down in an illegal manner. So this kind of so-called bulldozer justice goes against the basic tenet of crime being punished, because here the punishment is not given to the criminal who has done the crime, but to a larger number of people. Now, in the earlier times, punishment was supposed to be retributive, especially in the Roman times. Punishment was meant to, give a lesson to the person, and the intention was that punishment would be given proportionate to the misdemeanor or the crime that the accused had, committed. Now, over time, especially with the emergence of the utilitarian philosophy in the West, of Bentham and Hobbes, they've propounded the theory that when a crime happens, it is the responsibility of the state to give punishment in such a way that the criminal understands that the benefits of committing a crime are outweighed by the punishment that he is liable to get. So that was a purely, as they said, a utilitarian concept. But over time, this has now further been modified, and what we follow now is the reformative or the rehabilitative principles of punishment, wherein the intention of the punishment or the sentence is not to take revenge uh, on behalf of the state, but to give the person an opportunity to go into a prison where his his more human thought processes, his more human feelings are sought to be revived and nurtured, and so that when he comes out from jail after completing his sentence, he is once again a better and a useful and a productive member of the civil society. And the best way to describe the philosophy that goes behind this is to quote Mahatma Gandhi, who said that hate the sin and not the sinner. And Justice Krishna Iyer, one of the leading judges of the Supreme Court of India, is very famously said that every saint has a past and every criminal has a future. So that is the current thought process, the current philosophy behind the kind of punishments that are given out presently.
Right. And I'm glad you brought out that distinction between individual punishment and collective punishment, because there is this tendency, there's an impulse towards, mob justice, towards imposing collective punishments. And this is not new. I mean, there has been history of how social boycott was used against a particular family or community as a forms of collective punishment in our society and in every society world over. But of course, thought modern jurisprudence has evolved, criminal philosophies have evolved to make sure that only those individuals who are guilty of committing a crime are punished and so on. The other thing that you mentioned, that the purpose, the intent behind imposing sentence or punishment today is reformative justice. Now it's a matter of different debate as to how this is being actually carried out in our prison systems and criminal justice systems. But maybe we'll come to that in a separate episode, because there's a lot to be unpacked over there and how our prison systems work and so on. But thanks for setting this initial context, and let's dig right into what we plan to talk today, which is about how a murder investigation happens. So could you just walk us through the first steps of what happens immediately after a murder is reported? Who responds to the scene? How does the police and the magistrate swing into action, and what takes place at the initial stage?
So, in the case of a murder being committed anywhere, whether in the rural area or in a city, the first information is often relayed by an acquaintance or a neighbor or someone who's seen something happen, and the information normally goes to the control room, and the control room then informs the concerned police station where this incident has taken place, depending upon the jurisdiction in which that house or property is situated. As soon as that happens, the local thana, or the local police station, will swing into action and dispatch a team that will go there. And the first thing that they do is to what we technically call secure the scene of crime. And now, who goes there? Ideally, in a murder situation or other serious offenses, like, for example, a rape or a gang rape or something that serious, it is the SHO or the Thana in charge who would go. There may be other instances where the Thana in charge may be busy elsewhere, and his next in command will go. So, as I said, the first thing they do is to secure the scene of crime. What I mean by that is that the room or the location where the crime has taken place is cordoned off, so that people don't mill around. Why is this done? So that whatever evidence is there, and there's always some evidence, is not destroyed knowingly or unknowingly by those who are milling around, for press photographers, passers by, etc., etc. Now, once that is done, the second thing that is done is to talk to the person whose kith or kin have been murdered, and to try to figure out what are his initial thoughts, and then to ask him to write out a complaint in which he says that Mr. X, who was my brother or father or sister, has been shot dead or knifed or whatever, and he's in a pool of blood. He may say that I suspect that so and so, with whom he has a long-standing enmity, I suspect him. He may say that in his complaint, he may say that I saw a black car come and I saw people shooting from it, whatever the circumstances. Or he may just say that I don't know. I had gone out, I came back and I saw my father, brother, whatever, lying in a pool of blood. So this is what is called the FIR. The first information that is given to the police is called the FIR, and the section of law under which this is done is called Section 154 of the CRPC. So once this FIR is registered or lodged in the concerned thana, then the criminal justice system kind of cranks up into action, and the process of identifying the person who's died, trying to understand the circumstances in which he has died by talking to people, maybe now looking at a CCTV camera, analyzing his phone, and various other, talking to passers-by who may have seen, often it is some sabziwala who's crossing and he saw a black car come and go. It could be anything. So the process of collecting evidence to identify and to isolate the circumstances under which that murder has taken place begins. Now, that would involve talking to a lot of people, and it takes time. Parallelly, what happens is that the forensic team, the crime scene management, about which we had talked when we had discussed the forensics, the crime scene management team comes, and now, thankfully, most states, especially in the urban areas, have a reasonably effective crime scene management unit. They come and survey, examine the crime scene, and try to pick up whatever evidence is available. All that evidence is then collected, packed, and sent to the lab. The important thing while doing this is that it has to be ensured that the purity of the sample that is collected is not disturbed, is not maligned or in any way compromised, and that the chain of custody, which is a very important legal concept, that the chain of custody is very well defined. It should not be that I gave it to so and so and I don't know what he did and ultimately it landed up in the lab. No, everyone has to be. It was given to X. X took it by bike to the lab and gave it to the forensic lab assistant, Mr. Y, and they gave a tag to it, a number to it, and then they started processing it. So those are the first things that happen. Then obviously the process of collecting evidence is a long, tedious, non-glamorous process about which we can talk. If you have any more queries at this stage, we can handle that.
Yeah, so just a little bit on the FIR, right? So FIR is often the foundational document which initiates criminal proceedings, and the judiciary over the years has stressed that the police is under an obligation to record an FIR and all of it. So maybe could you spend 1 or 2 minutes talking about the importance of FIR, who can file it, what to do if the police officer refuses to file it, what are some of the rights that informants have and the accused gets with respect to the FIR?
Yeah. So, in a case of murder, for example, which you are presently discussing, the possibility of the FIR not being registered are more than remote. Definitely, a case would be registered. And who can get a case registered? Normally, it is someone who's a kith and kin, who's an interested party. Otherwise, why would a passerby get a case registered? It has to be someone who has a stake in the life of the deceased, and he would like to set the criminal justice system into motion. Why is the FIR important? It is important because being the first information, the chances are that it is not yet contaminated with opinions and biases and such other things. In fact, if there is a delay in the registration of the FIR, then the courts look at it with some amount of, with some kind of suspicion about why a FIR was registered, let us say 24 hours later or whatever. It could be that there was no person available the brother or the sister or the wife was living elsewhere, she came and got it registered. So if there's a delay, it has to be very well explained. If it is not explained to the satisfaction of the court about why there has been a delay, then the courts will keep that in mind when deciding whether the FIR, as it is made out, gives out the real story or there's an element of doubt in it.
Right. And the other thing is, of course, we need to keep in mind that FIRs are registered for cognizable offenses, while only a complaint is registered for a non-cognizable offense. The distinction there is technical. I mean, I think the schedule of the criminal procedure codes tells you what offenses are cognizable and which are not. But if you were to sort of simplify this, how would you say, I mean, if you're explaining it to a complainant, how would you distinguish between cognizable and non-cognizable?
Non-cognizable offenses are those that are simple in nature, a simple crime. For example, someone has given a slapped someone, or just given him a gali or two, or similar things which are simple in the context of the law. They invite the registration of a non-cognizable offense. Now, in a non-cognizable offense, we must clarify that it's not that investigation cannot happen. It is that if the investigation has to be done, then the police station does not have so motor powers to conduct the investigation. They have to take the approval of the court, the magistrate whose jurisdiction this incident has happened, and he may or may not permit that. But in a cognizable case, which is a more serious nature of case, for example, if someone were to be beaten back black and blue and his nose is broken, or his hand is broken, or he has a cut on his head, or five people have belabored a person, then it is a cognizable offense. Then the police has the authority under law to register what is called a cognizable case and then proceed without having to ask the magistrate about it. The FIR, the FIR has to be registered, and within 24 hours, a copy of the FIR has to be sent to the magistrate. Now, this is also an important, step. If there's a delay in that, then once again the courts feel that some, manipulation, etc., has been done, and the FIR is not really an FIR. Things have been added, subtracted, biases have been, put in, etc. So the magistrate gets to know about the commission of offense within 24 hours when a copy of the FIR is sent to him.
Right. So let's go back to the investigation bit. You said it's a tedious process, it's a time-consuming, slow, non-glamorous process, like you put it. And of course, it involves, examining witnesses, taking their statements. Or there can be instances where an accused is apprehended, but the investigation needs to proceed, or the accused may just, confess to the crimes. But again, there are restrictions on what the police can do and cannot do in such situations, all of it. So could you take a few minutes and just tell us how does this investigation take place till the accused is, committed for trial before the court?
Yeah, from the registration of the FIR to the filing of the charge sheet, which is the final report of the police under Section 173 of the CRPC, is a long, non-glamorous process, as I said. For example, if an incident has happened, then the first thing that has to be found out is what is the motive behind the incident. Because if you get to know the motive, then you are able to reduce the number of people who are suspect from a total global thing or a total whole of universe thing to 50 people or 20 people or whatever number of people. Then who was around when this incident happened? As I said, a sabzi wala may see a black car coming and going, or a neighbor who's hanging his clothes after washing may see two people running with their faces covered, or someone may see, or may hear shots being fired and come out and see two people sit on a bike and run away. And once that happens in today's times, two things have become very important. One is that a large number of places, especially in urban areas, have CCTV, cameras, which have been set up by societies and RWAs and others. Often those cameras capture the coming and going of an individual or set of individuals. Then the mobile phone is another very important, tool to gather information about who could have been here. I mean, there are technologies now available to find out who all was present in this area between, let us say, 11:30 and 11:45 when this incident happened. So that kind of data analysis is done, and most police forces now have a reasonably good understanding and capability of doing this kind of work to zero down upon the number of mobile phones that were in that area. And once you have the mobile phone number, then you are either looking at a telephone number or you're looking at an IAEMI number, which has been used by the assailants, and you try to proceed from there. So this process takes time because often the people are reticent about coming before the police and giving information. We discussed this the last time that the Evidence Act expects that people will come forward, but the reality is that people want to stay away from it because of a variety of reasons. So when the whole process is done, then a stage arrives where the accused or the suspect in this case, at this stage is a suspect, maybe one or multiple, he is detained and questioned. And then one tries to figure out the motive behind his doing whatever he did. One tries to corner him on why he was on so and so road at so and so time, who all was with him, and all that. So, that, as I said, these things happen in the confines of the interrogation room and take a lot of time. And once that is done, someone may have a good alibi that I was not there. I was sitting in for an exam, or I was traveling. There's a ticket, or whatever. Whereas others may not be able to explain their conduct. The previous criminal history of a person also becomes important, because if criminals have a particular modus operandi, there are some people who will knife a person to death, some others who will shoot a person. If he shot someone, then the weapon that he has used can be connected to another crime that he had committed in the past. Ballistics comes in. So all that is done, and then at some stage the police is able to zero down on to say that A, B, and C have done it, or PQR have done it, and then the charge sheet is filed in the court of law.
Right. So one question to you before we talk about charge sheet and the trial process itself. It's on the bail, the right of bail, right? Of course, the law sees bailable offences and non-bailable offences, and these are again prescribed in the schedule to the CRPC. So, what is the law surrounding the bail for an accused like someone who's accused of murder? What happens there? Is there a default bail provision? Is it readily made available to the accused, or are there requirements that this person is committed or detained in prison till the trial is over?
Yes. In the CRPC, there is a schedule of offences which are divided between cognizable and non-cognizable. We just talked about it. In that schedule, there is always also a column about whether that crime is bailable or non-bailable. If the crime is bailable, then the police station concerned can let out a person on bail. On the other hand, if it is non-bailable, then the police cannot give bail to a person. He has to be produced before the concerned magistrate or the concerned court. Now, once he is before the court, then the lawyers on behalf of the accused have the option of moving a bail. And depending upon the evidence that has been adduced against this particular person by the police, and whatever defense the accused may have, which is put up before the court will decide whether to let out a person on bail or not. Now, in certain cases, especially in matters of grave sexual offense and in murders or gang rapes or some such other, a terrorist act or something like that, the chances of getting bail are very remote. But in other cases, for example, of public affray or of theft of a bike, the chances of getting bail are more. So depending upon the facts of the case and the previous conduct of the accused, bail is decided. There is an element of discretion in this. It can be given by the court and it cannot be given. It may be refused by the court. If they are unable to get bail in the sessions court, then the accused has the option of moving the Honorable High Court, where under Section 438 of the CRPC, the High Court has the powers to look at the bail application which is filed.
Right. So now let's say, like you said, the charge sheet has been forwarded to the magistrate, and now there is this whole process where the magistrate actually asks the accused whether he pleads guilty or not guilty to a crime. The person pleads guilty, the court can produce judgment then and there. Otherwise, the trial ensues. But there's an important step of framing of charges that takes place at this juncture. So I want to know from you, what is the process behind framing of charges? How are decisions made about specific charges? And is there a lot of leeway which is available to the police or the court in framing of charges, and if the accused can contest it?
Yeah. So when a charge sheet is filed, the first thing that happens is that the magistrate takes cognizance of the case, which means that he formally acknowledges that a murder had happened about which an FIR had come 2 months, 3 months ago. And now, in that same case, a charge sheet has been filed in which ABC have been arraigned as accused persons. And once he commits that case, then it goes to the magistrate or the session judge, as the case may be. In the case of murder, it is a session judge where the trial will be conducted. Now, once it goes to the session judge, then the first thing that happens there is that all the documents that have been relied upon by the police to make out a case against the person, a copy of that, a readable copy of that, is provided to the person, to the accused or his lawyer, by the police or the prosecution. This is as per section 207 of the CRPC. Now, this process can take a lot of time because, you have to make available, for example, if there's a CCTV footage, you have to give him that in a pen drive. If there are telephone records, you have to give that in a pen drive or in a CD. If there are documents, then copies of that have to be made. And this is the stage when the defense lawyer will say, these are not legible, give me another copy. He will, say, now, the pen drive that you have given is scratchy, whatever. I mean, he will try to delay it, or he may try to delay it. Now, once the documents have been provided to the satisfaction of the court, and they know the conditions or the reasons why they have been made an accused, then the court frames the charges in the presence of the defense and the prosecution. The framing of the charge means that whatever action the person has done, or criminal action the person has done, involves the breach of certain sections of law. So he will say that by murdering A, Mr. X has committed the offense of 302. He will also say that when you came in, you beat him up before, killing him. Then this 324 or something like that will be also added. If that person has been confined in his room before he's killed, then section 342 will also come in. So if there have been attempts to shoot and someone else has escaped, for example, they try to shoot and his wife or the son or whatever, or the servant, he jumps out of the window and runs away, then that's a 307. That will be also added. So every action of his during the course of the crime, which has been recorded by the police, will be converted into a section of law which is violated. And then once the charges are framed, as you said, then the accused has the option of either denying it or accepting it. In a murder case, I have not known anyone accept it, but technically, yes, he can do that. So once that happens, then the process of trial has to begin. Now, the process of trial involves examination of all the prosecution witnesses that have been arraigned by the police to prove my case. That is a very problematic and long and time-taking process, because each prosecution witness's statement is recorded. You'll be surprised that the statements, even in 2023, are recorded by hand by the magistrate who keeps writing on his paper. And obviously, it takes time. And once that statement is recorded, then the defense is given the opportunity to cross-examine the witness, or the prosecutor has the option to ask supplementary questions.
Stay tuned to All Things Policy. We'll be right back after a short commercial break. Right. And like you mentioned, the role of public prosecutor here, he's essentially leading the case and plays a very pivotal role during the trial. So, on the other side, I want to know a little bit more about the defense representation. Of course, now the accused can engage any lawyer to defend him in the court, but the state also provides legal aid in case that person is unable to, afford a lawyer or engage one. But in this whole process, the case is essentially between the state and the accused, and the victim does not get much representation. Although a little bit of change in law was made to accommodate victims of sexual violence so that they get some representation in this process. So I wanted to know from you: is that the only situation in which the victim gets represented at the trial, or are there other exceptions or possibilities?
I think you raised a very important point. The fact that the state becomes the complainant before the court, because it is the state at the philosophical level feels that the state has been violated when he has committed a murder. So the state is the prosecutor. So the state takes it upon itself to prosecute the person and bring him to justice. Now, unfortunately, in India, except for the sexual offense cases which you talked about at the stage of bail, the victim now has some say in the matter about whether bail has to be given. In most other cases, the victim does not have much of a say. This is a developing, area of jurisprudence in India, and I really hope that more progress is made on this, because till the victim is satisfied about a fair trial, there's always a feeling of having been let down by the public prosecutors, who may or may not have the same kind of motivation as someone who's lost a near and dear one. So in some countries, the victim has much more say in the process. For example, in New Zealand, he has a say in deciding which prosecutor will appear on my behalf, so on and so forth. So, as I said, this is a developing field, and I really hope that the victim rights get more, enhanced in the years to come as jurisprudence on this develops.
Right. So you briefly mentioned the trial aspect and how slow and tedious this is, and also so how tech unfriendly it is if magistrates are still taking down depositions by hand. But could you just take us through what happens at a murder trial? What are the various stages, and what is the things that we need to look out for?
Like in every other trial, the court examines all the prosecution witnesses who have been produced by the prosecution, and the defense has the opportunity to cross-examine them and essentially to create doubts about the story that prosecution witness is placing before the court. Increasingly, because forensic science is becoming more important now and more being used more in investigation, the expert, who is a person who is well versed in a field, is also examined. He's also invited under Section 45 of the Evidence Act, and he comes and deposes before the court and tells the court about what evidence he has culled out from the samples that were produced by the prosecution to him in his lab. And that is where, as I talked about earlier, the chain of custody is an important thing. The first line of attack of the defense is that the sample that you examined is not what was collected from the scene of crime. So the chain of custody becomes very important, and the non-contamination of the sample becomes very important. So this once all the prosecution witnesses have been examined, then the defense can give a list of witnesses that it wants to be examined. They are called defense witnesses. Now, their number could be whatever, 10, 15, 20, but the court has some say in deciding that out of the 20 defense witnesses that you want to be examined, only 5 or 7 or 10 are relevant, and we will examine only these. And that number of witnesses are examined. The court also has powers to re-examine a person who's been examined in the past. That is the domain of the court. So once all the witnesses have been examined, then the trial reaches the stage where both the sides give what is called the Section 313 statement or report, in which, in brief, they give out the whole case that they made out against the accused, whereas the defense will try to pick holes in that story and give out its reasons why the opinion of the prosecutor should not be relied upon.
Right.
Once these two things are available with the court, then it is on the court to take a view.
Right. And this is what essentially we call the stage of judgment, right? So once
Yes.
the depositions take place and the statements are given to the court, the evidence has been presented, both the cases have presented their arguments, the court essentially reserves the judgment, has to apply its mind to the facts presented before the court. Then it has to look at the provisions of law and has to arrive at a conclusion whether it can be proved beyond reasonable doubt that the accused has committed the offense or not. So let's assume this process of judgment takes place. The court hands out a verdict of guilty against the accused. And I want to know from you, how does the next stage, which is also equally important and which is sort of the culmination of the trial, that is the sentencing stage, takes place. So how is sentencing determined for a crime like murder? What are the kinds of punishment that can be imposed? Who gets a say? And how does the judge essentially decide the question of sentencing?
Yeah, so you're right that once a person has been declared guilty, then the court takes another day or two or maybe a week to pronounce another order about the sentence. Now, there is no hard and fast rule about how much the punishment will be given out to an accused. There are the law says that a maximum of 10 years or life imprisonment can be given, or 14 years can be given. At times, there is also a minimum that is provided, that you cannot give less than. In a murder case, it's a life thing. It can go up to life. So, depending upon the circumstances in which a murder happened, the judge, in his discretion and in his best wisdom, he decides what is the quantum of punishment, or what is the length of time that the person will have to spend in jail. Now, he may, for example, if there's a murder and there was also an attempt to murder, there was as I said, a servant who was shot at, he jumped out of the window and went away. So there will be a punishment for the murder, and there will be a punishment for an attempt to murder. And for example, if they have done something else, then be a punishment for that also. In India, most of these punishments will run concurrently. For example, if it is 10 years for the murder, for the attempt to murder, and 1 year for something else, then all these will run concurrently. So in effect, the maximum punishment that is given, that is 10 years in this case, would be the period of the incarceration. In the US, for example, they run not together but one after the other. So 10 years for this, 2 years for this, 1 year for this. That is why in the US you find that someone has been convicted for like 232 years or whatever it is.
So yeah, 2 quick points on sentencing. Actually, I think there is a policy vacuum here, and there are people working on this, but we don't have conclusive policy yet on first sentencing guidelines. I mean, there have been precedents given by the court which say that there are these factors regarding the life of the accused and the crime that he has committed that needs to be considered by the court before handing out any sentence. But we as such don't have any sentencing policy or guidelines, although attempts have been made to create one. And the second is our penal code relies on imprisonment heavily as the only means of punishment, while penalties or fines have been given a secondary status, right? And in fact, there is a good case to be made that we have to move away from imprisonment as the default option to fines, to monetary penalties that can be imposed for offenses. And this is especially true for document-related offenses or property-related offenses, and maybe even in case of some body-related offenses like causing hurt or injury, and these smaller kinds of offenses. Anyway, having said that, let's go back to our process, the criminal trial process that we were talking about. Now, even if the judgment has been handed out, the process does not end with the judgment, right? Because there is a right to appeal which the law provides to the accused, so that a higher court can take a relook at the case and decide if it was decided correctly or not. So I want to know from you 2 things. One is what is the limitations upon the powers of the High Court and the Supreme Court in terms of hearing appeal cases? And second, does the police play any role at all in the appellate stage, or is it just a legal process?
Yeah, so first thing that has to be said is that there's almost no limitation on the powers of the High Court or the Supreme Court, and more so in the case of Supreme Court. Now, when an appeal is filed, then the constitutional courts, that is the High Court and the Supreme Court, don't look at facts. They will not go and find or try to figure out whether the black motorcycle had come or a red motorcycle has come. Someone says, no, motorcycle was red. They will look at the process. They will look at whether the due process of law as defined under Article 21 has been followed. Whether the evidence that has been adduced was admissible evidence, and such other matters. So they will look at the process of the trial, whether it has been done, in a manner which is in keeping with the law or not. If there is any doubt on that, the chances are that the benefit of doubt will be given to the accused. They may also, let out a person on bail, which happens quite often because they feel that he's already spent 6 months or 1 year or 2 years or 3 years, and now the trial is going to carry on for another 5 years. So there's no need to keep him in custody, and he's let out on bail. There's a very strong jurisprudence in India, especially about 20-25 years ago, where bail was the norm and jail was not jail was the exception. In the last 15 years or so, one can say that this bail not jail theory of jurisprudence has got diluted, and there are more chances of a person being kept in jail for long periods of time. So these are philosophies of jurisprudence that judges have, and these keep changing until till there is, in fact, there cannot be a very watertight rule about who is to be given bail or not bail. So that is where luck, if I can use that word, comes in. That is where the philosophy of a judge comes in, and that is where the skill of the lawyer who's arguing your case comes in. What kind of arguments he makes. He probably knows the philosophy of the judge, and he hammers on that so that he can have the ears of the court.
Right. So it's a little concerning that you said, there are no limitations upon the powers of the higher courts in deciding the case on appeal, because ideally there is supposed to be, right? Like the grounds of review are supposed to be limited. And like you mentioned, they, of course, cannot reappreciate the evidence. They need to look at the process. It's more of a process review. But broadening the powers at the appellate stage, in fact, hinders the whole process of criminal trials. But having said that, let's move to the next stage. Let's say the accused has exhausted all his appellate remedies, and there is nothing left for him to do other than live out his life in prison. But again, there is a catch here. That is the idea of clemency, which our executive authorities at various stages are empowered to grant under the Criminal Procedure Code and under the Constitution, as far as governor of a state or the president of India is concerned. Now, there are different ideas of clemency and different terms are used to describe this, some of which are remission, commutation, respite, reprieve, pardon. So I want to know from you the distinctions between all of these. Is there a difference? How does this come into picture? What are the grounds which the government or the governor or the president has to look at before granting clemency under the provisions of the code or the constitution?
So the first thing that needs to be said is that these powers are given to the President of India and the governor of a state as part of their sovereign powers. And these powers are not justiciable. Secondly, the circumstances in which the incident has happened has an important role in deciding whether the appeal for remission or parole or whatever is accepted or rejected. The third thing is that all these concepts of remission and parole and furlough are based on the restitutive punishment system that is the base of all punishments in India. The purpose behind giving these furlough or parole or whatever is that the person has an opportunity to it is a humane act in which a person has the opportunity to attend his daughter's wedding or look after his wife who's terminally ill, or to attend to the last rites of his father, and stuff like that, so that when he ultimately goes out after completing his sentence into the society, he is still kind of linked to the society, and he is not kind of disappeared for 20 years and then he emerges and no one knows him. His social links have been have dried up and things like that. So that is the basic reason why these are sovereign powers given to the governor and the president, and why these powers are exercised, right? Because it is a reformative process. That is the philosophy behind it. Now there are various ways in which some leeway is given. Most of these are provided in the Prison Act of the states. The states have their own prison acts, and each state defines the circumstances under which furlough is to be given or parole is to be given or remission is to be given differently. But the basic premise is, as I said, so that he can go back into society and become a useful member. And now the first relief that is given is furlough. Furlough is given in cases where there's a long conviction, 5 years, 7 years, and a person has spent 2 years in jail, and his conduct has been good, and the crime for which he has been convicted is not a very heinous crime. For example, he's not involved in a gang rape or something like that. So, depending upon his good behavior in the jail when he's been incarcerated, he is given a period of furlough in which he goes back and spends time with his family, so that his links with the family are kind of revived and kept going. Now, the difference between furlough and parole is that if someone were to be serving a sentence of, let us say, 5 years, and he's given a furlough of 1 month, then this 1 month is kind of off from his 5 years. As against this, in a parole, if he's sent out for 1 year, then he has to come back and complete those 30 days. So that's one major difference that is there between furlough and parole. Parole also the grounds are the same, that he has to look after his family, that he wants to attend a family function or bereavement or a shadi or whatever it is. A remission is given in slightly more rare cases where the period of incarceration is remitted, where that instead of serving 5 years because of his good conduct and all that, and the nature of crime that he has committed being not that grave and serious, he is let off after 4 years and 6 months or whatever it is. So these are the more common methods or tools available for relief to the convicts.
Right. And of course, like you rightly said, the president and the governor have certain sovereign powers as far as the pardons that they can grant, right? And this is, although you said it's non-justiciable, but I do think like the courts have assumed themselves the power to exercise judicial review over the decisions of, commutation of death sentences and so on. So that's something else that we've seen.
So the courts don't challenge the power of the governor or the president. They look at the process that has been followed.
Right.
So there's a difference.
Yeah. But in any case, Mr. Ahmad, thank you so much for joining me on this episode today and taking us through this lengthy process of criminal trial. And we hope that, the moral arc of this entire process bends towards justice or criminal justice. So thanks once again for this conversation today.
Thank you, Shrikrishna. It's been a pleasure. Thank you.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.